The courtroom had learned to trust loud voices. They echoed better against wood-panelled walls. They carried confidence. They sounded like certainty. The judge leaned forward when they spoke. Jurors nodded. Pens moved. Elias Turner did none of those things. He sat on the hard bench near the back, hands folded neatly in his lap, shoulders slightly hunched as if trying to take up less space than the room allowed. He was a black man in his late 50s, dressed in a plain grey suit that had been pressed too carefully, like someone who believed presentation might compensate for not being expected to matter. When he spoke, it was soft, measured, precise, and for that reason alone, no one took him seriously. The case had already decided itself in the minds of most people present. A white real estate developer stood accused of falsifying public records tied to a housing project that had displaced dozens of families. The defense called it a clerical misunderstanding, a paperwork issue, an unfortunate mix-up in dates and signatures. The prosecution struggled to make it sound like a crime. Elias had been called as a secondary witness, not an expert, not a star, just a records clerk from the county archives who had been listed at the bottom of a long witness list no one expected to reach. When his name was called, a few jurors glanced up, then quickly back down. Elias walked to the stand carefully, adjusting the microphone so it didn't squeal. He cleared his throat once. "Please state your name for the record," the prosecutor said. "Elias Turner," he replied quietly. "Speak up, sir," the judge said, already impatient. "This is a courtroom." "Yes, Your Honor," Elias said, a little louder, though still calm. The defense attorney leaned back in his chair, barely concealing a smirk. He had already assessed Elias, soft-spoken, older, non-threatening. Someone who would fold under pressure or get lost in his own explanations. "Mr. Turner," the prosecutor continued, "what is your occupation?" "I manage historical land and permit records for the county," Elias said. "I've worked there 32 years. The number hung in the air, unnoticed. The prosecutor asked a few preliminary questions. Dates, filing systems, procedures. Elias answered each one clearly, without embellishment. No confidence theatrics, no emotional weight, just facts. The defense attorney sighed audibly. When it was his turn, he stood slowly, buttoning his jacket. "Mr. Turner," he said, voice smooth and dismissive, "you're not an accountant, correct?" "No, sir." "Not a lawyer?" "No." "Not a forensic analyst?" "No, sir." The attorney smiled toward the jury. "So you're essentially a librarian?" A few people chuckled. Elias didn't react. "I work with records," he said. "Original ones." The attorney waved a hand. "Right. Old files, paperwork. And you expect this jury to believe you uncovered something that multiple firms, auditors, and agencies somehow missed?" Elias looked at him steadily. "Yes," he said. "Because they weren't looking for it." The attorney raised an eyebrow. "And you were?" "I was filing it," Elias replied. There was a pause. The judge glanced down at the clock. The defense attorney smirked again. "Mr. Turner, with all due respect, this case involves millions of dollars and complex transactions. It's hard to imagine a quiet records clerk uncovering a conspiracy no one else noticed." Elias nodded once. "That's because," he said gently, "people assume records don't talk back." The courtroom shifted slightly, not enough to register as interest, but enough to change the air. Elias reached into the folder beside him and placed a thick stack of documents on the stand. They weren't highlighted, they weren't color-coded, they weren't flashy. They were original, stamped, dated, logged by hand. "I didn't find the truth by being loud," Elias said. "I found it by listening to what the records were saying when no one else bothered to slow down." A few jurors looked up now, not convinced, but curious. And Elias knew that was enough to begin. Because the court might doubt a soft-spoken witness, but it had no idea what 32 years of careful records were about to expose. The defense attorney tried to move on quickly. He shuffled his notes, clearly irritated that the exchange had lingered longer than planned. "Let's be clear," he said, pacing a few steps. You didn't conduct an investigation. You didn't run audits. You didn't interview anyone. No, Elias replied. I catalogued documents, the same way I always do, the attorney scoffed. So this is just your interpretation. Elias shook his head slowly. It's not interpretation if the records agree with each other. That earned him a glance from the judge. The prosecutor seized the opening. Mr. Turner, she said, can you explain what you mean by that? Elias adjusted the papers in front of him, aligning the edges carefully. His hands were steady. They always were. 32 years of handling documents taught you patience, and patience taught you control. In our archive, he began, every land transfer generates 3 independent records: a permit log, a tax assessment update, and a zoning acknowledgement. Different offices, different clerks, different filing systems. He paused, letting the words settle. When those records don't match, he continued, it's usually a mistake, a typo, a delay. But when they don't match in the same way, repeatedly, over multiple years, across multiple properties, then it's not a mistake. The defense attorney opened his mouth, then closed it. Elias slid the first document forward. This permit shows a demolition approval dated March 3rd, he said. This tax record shows the same property listed as occupied until July, and this zoning acknowledgement, filed 2 weeks later, retroactively authorizes the demolition. A murmur rippled through the gallery. The prosecutor leaned in. And how many times did this pattern appear? Elias didn't hesitate. 27. That number landed harder than any raised voice could have. The defense attorney stood abruptly. Objection! This witness is drawing conclusions beyond his expertise. The judge frowned. Overruled. He's describing records. Elias continued, still calm. Each time, the retroactive document bears the same authorization signature, not the same person, just the same stamp. A stamp that was officially retired 3 years earlier. Now the jurors were fully paying attention. The defense attorney's confidence wavered. Mr.
Turner, he said sharply, are you suggesting my client orchestrated this? I'm saying, Elias replied, that someone relied on the assumption that no one would compare these records side by side. Silence filled the courtroom. The judge leaned forward. Mr. Turner, he said, voice slower now, how did you notice this? Elias thought for a moment before answering. Because I've been there long enough to remember when the systems changed, he said, and because I never stopped filing the old way. A few jurors exchanged glances. The prosecutor asked one final question. Did you alter or annotate any of these documents? No, Elias said. I preserved them. The defense attorney sat down heavily. For the first time that day, Elias felt the room turn toward him. Not because he was loud, not because he demanded it, but because the truth he carried was too orderly to ignore. The court had doubted the soft-spoken witness, but the records were beginning to speak for themselves. By the time the court recessed for lunch, the mood had changed. Conversations in the hallway were no longer casual. Lawyers whispered instead of joked. Reporters who had barely looked up when Elias first took the stand were now scrolling furiously through notes, replaying his testimony in their heads, already sensing a shift in the story they thought they were covering. Elias sat alone on a bench near the vending machines, eating a sandwich he had packed that morning. He chewed slowly, methodically, the way he did everything. Courtrooms didn't make him nervous. Noise did. And the quiet hum of the building settling around him felt familiar, almost comforting. A young assistant prosecutor approached hesitantly. Mr. Turner, she said, can I ask you something? Elias nodded. Of course. How long did it take you to put all of that together? Elias wiped his hands on a napkin. About 7 years. Her eyes widened. 7? I noticed the first inconsistency in year 2, he said. I didn't know what it meant yet. I just remembered it. Then another one showed up. Then another. I kept copies.
Not because I suspected a crime, because patterns don't reveal themselves all at once. She shook her head quietly. Why didn't anyone else see it? Elias thought about the archive room. The rows of boxes no one visited unless forced to. The rush to digitize without understanding what context got lost in the process. Because everyone was looking for summaries, he said. I was looking at originals. When court resumed, the defense tried to recover. They called expert witnesses, accountants, analysts, consultants with impressive credentials and confident voices. Each one explained how complex systems could create anomalies, how data migration caused errors, how retroactive authorizations, while unfortunate, were not unheard of. Elias listened from his seat in the gallery, hands folded, eyes calm. Then the prosecution did something unexpected. They recalled him. A murmur ran through the room as Elias returned to the stand, adjusting the microphone again. This time, the judge waited. Mr. Turner, the prosecutor said, earlier you mentioned preserving documents. Can you explain what that means in practice? Elias nodded. When records were flagged for digitization, many originals were scheduled for destruction after scanning. I requested exemptions for any file with conflicting metadata. The defense attorney shot to his feet. On what authority? County Archival Statute, Elias replied. Section 14b, Preservation for Unresolved Inconsistencies. The judge nodded slowly. So these documents, the prosecutor said, holding up a folder, exist because you intervened? Yes. And had they been destroyed? Elias met the jury's eyes, one by one. There would be no way to prove the sequence of alterations. The defense attorney objected again, but weaker this time. The judge overruled him without hesitation. The prosecutor continued. Mr. Turner, did anyone ever ask you to stop flagging these files? Elias paused. Yes, he said. The courtroom stilled. Who? The prosecutor asked. Elias named a department head, then another, then, finally, a consultant tied directly to the defendant's firm. Each name landed with quiet weight. Not accusation, documentation. The defense attorney's face drained of color. Elias wasn't speculating. He wasn't theorizing. He was remembering. When the judge called for a brief recess, jurors remained seated, staring at the documents now projected onto the screen. The narrative had shifted from confusion to clarity, from doubt to chronology. Elias stepped down from the stand for the last time that day, his knees stiff but his mind steady. As he passed the jury box, one juror nodded at him, not out of sympathy, but respect. The court had doubted the soft-spoken witness, but now it understood something fundamental. The truth didn't need to shout. It only needed someone patient enough to keep it intact until the moment it could no longer be ignored. The verdict came late in the afternoon, after hours of deliberation that felt heavier than the entire trial combined. Elias sat in the same place he had occupied all week, hands folded, eyes lowered, listening to the low murmur of the courtroom as people shifted in their seats. He didn't speculate, he didn't hope. 32 years of working with records had taught him that outcomes revealed themselves only when they were ready. When the jury returned, the room stood. The foreperson's voice was steady as the verdict was read. Guilty, on multiple counts, falsification of records, fraud, conspiracy. A breath moved through the courtroom, not applause, not relief, but release, like a structure under strain finally allowed to settle into its true shape. Elias closed his eyes briefly. Across the room, the developer stared straight ahead, stunned. The defense attorney gathered his papers without meeting anyone's gaze. Reporters rushed for the doors, already framing headlines that would never fully capture what had actually happened. Because the story wasn't about a dramatic cross-examination or a clever argument, it was about patience. The judge thanked the jury, then looked directly at Elias. Mr. Turner, he said, this court recognizes the extraordinary diligence demonstrated in your work. Without it, this outcome would not have been possible. Elias stood carefully. Thank you, Your Honor. His voice was still soft. It didn't need to change. Outside the courthouse, microphones appeared almost instantly. Questions came fast and loud. How did it feel to take down a major developer? Why didn't you speak up sooner? Do you see yourself as a whistleblower? Elias shook his head gently. I didn't take anyone down, he said. I kept records the way I was trained to. A reporter frowned. But you exposed the truth. Elias considered that. The truth was already there, he said. I just made sure it didn't get thrown away. That quote led the evening news. Back at the county archives, nothing looked different. The same rows of boxes, the same fluorescent lights, the same quiet that most people found uncomfortable. Elias returned to his desk the next morning and resumed filing, his movements as careful as ever. But things had changed. Requests came in from oversight committees. Training programs asked him to consult on preservation protocols. Younger clerks stopped by his desk with questions, not about the case, but about how to do the work properly, how to notice what others missed. Elias answered them all. One afternoon, a new hire asked him why he never tried to move up, why he never pushed for recognition before now. Elias smiled faintly. Because the work doesn't need a spotlight, he said. It needs continuity. Years later, policy reforms traced their origins back to that trial. New safeguards were implemented, preservation statutes strengthened. What had once been considered tedious archival work became recognized as a line of defense. Elias retired quietly not long after. On his last day, he labeled one final box, slid it into place, and paused for a moment in the aisle. Around him stood decades of truth, waiting, patient, intact. The court had doubted a soft-spoken witness, but history would remember something louder than doubt. It would remember that when everyone else rushed forward, one man stayed behind long enough to make sure the truth was still there when justice finally came looking for it.